things. So Roe deemed abortion to be a fundamental right under the Constitution based on this right to privacy, which they found emanating somewhere from the Bill of Rights in these previous cases. And not only the Texas law was overturned, but any law in any state which restricted access to abortion was overturned. Again, we're talking about at least the roots of the right to privacy that they have found, and they reference quite a few, not just the cases that we've talked about, but some other cases as well. So the right to privacy, this is directly from the opinion, the right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the 9th Amendment, reservation rights to people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. And so they were trying, I think in writing this opinion, he was trying to make it as broad as possible to bring in as much legal firepower as he could to make this be the final say on the abortion issue. So that was the decision. It was handed down. That's the law of the land. So let's talk about what Roe actually said. And I want to preface this by the fact that we are going to address this a little bit, but I want you to think about it while we're talking about this, because the Casey decision in 1992 actually obliterated this trimester structure in Roe. So especially if you're dealing with Planned Parenthood at all, Planned Parenthood will go in and tell high school kids and tell other people that abortion after the first trimester isn't legal, which is a total lie. But they point to this trimester structure that was put in place by Roe. The only problem is, as of the 1992 decision, that trimester structure is gone. They did away with it. And we'll talk about that in a little bit more detail. So states' rights under Roe, they still did preserve a few of them. In the first trimester, virtually no regulations are allowed. The second trimester, some regulations may be permissible, but the mother's health must be protected, and we will talk about the health. And third trimester, abortion can be prohibited, but again, you have to have that health exception. So I don't know how many of you know this, but Roe was not the only decision that was handed down during that session of the Supreme Court. There was also a decision called Doe v. Bolton. And Doe v. Bolton defined what the health exception actually means. So this was a Georgia law, and it was a Georgia law that was challenged. And they actually allowed abortion in more circumstances than Texas did. It included rape, fetal deformity, and fatal injury to the mother. And the abortion had to be approved. You can see that some of the restrictions. Interestingly enough, this is kind of parallels what the law on abortion used to be in Oregon. Oregon was one of the first states to legalize abortion. And we had a similar structure. It had to be done in a hospital. You had to have two doctors' opinions. What I find interesting is, looking from our perspective now, we would love to have that old law back, even though it was a very forward-thinking law to legalize abortion at that time. We would be saving a lot of lives if we had that law now. But and you had to be a Georgia resident, so you can see that. So this law was also going through the system at the same time as the Roe decision was, and it was actually decided at the same time as the Roe decision. And the importance of this decision is, there's a few more interesting tidbits about it. So again, it was a national cause to get the right to abortion up to the Supreme Court. So health. All right. This is the decision that defined health, and this is what health is defined as. Medical judgment may be exercised by the abortionist, in light of all factors, physical, okay, emotional, psychological, familial, and the woman's age. So this is relevant to the well-being of the patient. All these factors may relate to health. This is the hole that you can drive a Mack truck through whenever you have a health exception to any law relating to abortion. There literally is no reason not to have an abortion under this definition. So, and this is probably why you don't find a lot of abortion activists talking about Doe v. Bolton, because this definition of health is very broad. So the impact of both of the decisions together is essentially what we have now, which is abortion is legal nationwide for any health reason, and health means basically anything. And the only exception to this, of course, is the federal ban on partial birth abortion, which was a huge victory for us. Probably not in the number of abortions that it is stopping, but in the actual case law and what was said in the opinion. So we spent, for those of you in the room, you probably, if you were active during that time, really the focus was, so now it took it out of the states and put it squarely at the federal level, and the focus of the pro-life movement at that time was a constitutional amendment. And worked on that very, very hard for a lot of years. And constitutional amendments, obviously, are extremely difficult to get through. I mean, I think I would probably say, short of a revolution, that it's nearly impossible at this time in our history to amend the Constitution. We are divided and diverse, and I think we've moved beyond the ability to amend the Constitution in the way that it's laid out. But, I've been wrong before. I thought McCain was done and wasn't going to get the Republican nomination in August, and I was wrong about that. So, but there were a lot of very smart pro-life lawyers and legislators who were thinking about, okay, Roe v. Wade has left us a little bit of wiggle room. Where can we go with it? And that's how we came up with the Casey, Planned Parenthood of Southeastern Pennsylvania v. Casey. It was Governor Casey, a Democrat from Pennsylvania, and he had signed, they had passed a series of pro-life legislation in Pennsylvania that included several restrictions that they thought would have the possibility of being upheld by the Supreme Court under Roe v. Wade, and they wanted to try it, so they did. And this case did, of course, Planned Parenthood challenged it. They didn't like it. And they challenged these 5 provisions, and some of them may look familiar to you: informed consent, spousal notification, parental consent, 24-hour waiting period, and then reporting requirements. And the one and only thing that we have in Oregon, we do actually have very good reporting requirements on abortion, and so we have a lot of information about where and when and how old the baby is and how old the mom is when they have abortions. That's the one thing that we have, and there are states that don't have as good of reporting requirements. The Casey was decided 5-4, a split decision. But they reaffirmed the central holding of Roe, which is and what that central holding is, there is a right to privacy that covers the right of a woman to terminate her pregnancy, to kill her baby. That was the central holding. And Sandra Day O'Connor was the swing vote on that, in that central ruling. But they voted 7-2 to say that the states do have an interest in protecting potential life. So they moved a little bit. So because of that, the spousal notification was held unconstitutional because it violated the woman's right to privacy. But they upheld informed consent, one-parent consent, and reporting requirements. And you'll notice there's also a note about the judicial bypass. Casey is the reason why we look at, now in Oregon we have to have what we call an administrative bypass, because the Oregon Constitution has this funky provision that you cannot have a private meeting with a judge. And we made the decision that we did not want a girl who was, if she was in an abusive situation, incest or other kinds of abuse, we would not want that discussion with a judge to be public, and it would have to be if it was judicial. So we have an administrative bypass if we ever get this law passed. When we get it passed, finally, that we have administrative law judges who can meet with minors in private. So, but this is the reason why we have to have it, because this Supreme Court decision said you have to have some kind of out for a girl who is being abused by her parents. So what has been the practical application of this is that the abortion rates have gone down in states. Now this graph is only through 2005. We couldn't find one that was more recent than that. Statistics tend to lag behind quite a few years. But you can see this line is about 1995. The 1992 decision came down, and other states started to pass these laws, and we began to see a dramatic decrease in abortion rates. And so not only, they really were experimenting to see what kinds of things they could pass and would be upheld under Roe. We were also looking for opportunities to slow down the abortion decision process, because we know that when we slow it down, girls choose life. And so this did actually happen. And that was sort of the proof in the pudding. And other states in the pro-life movement kind of started to pivot and work on these kinds of laws. And that's basically the history why behind some of the legislation that we're working through. Oh, nice little red line there. Okay. So the end result is that your vote does determine who eventually gets on the Supreme Court. President gets to appoint that person. We're up against another one, thankfully. Justice Stevens, shouldn't say thankfully. The balance of the court will probably not change. It would have been great to have this opportunity with a pro-life president, but we don't. We did have the opportunity to put two good justices on the court, but with Stevens retiring and being replaced with someone who will be appointed by Obama, who's already been winking and nodding sending messages that he's only going to choose somebody who will uphold Roe, that it won't change the balance of the court. So that's the good news and the bad news.